In the US privacy laws, personally identifiable information, PII, stands as a fundamental concept, central to understanding how privacy rights and protections are applied in various contexts, including but not limited to healthcare, finance, education, and online commerce. PII refers to any information that can be used on its own or with other information to identify, contact, or locate a single person, or to identify an individual in context. The importance of PII. The categorization of information as PII is crucial because it dictates the application of privacy laws and the obligations of entities that collect, process, or store such information. With the digital age ushering in vast amounts of data collection and processing, the protection of PII has become paramount to safeguarding individual privacy rights. Legal frameworks governing PII. Several US laws specifically address the protection of PII, including the Health Insurance Portability and Accountability Act, PII, governs the protection of PII in the healthcare sector, focusing on the confidentiality and security of health information. The Family Educational Rights and Privacy Act, FERPA, protects the privacy of student education records, which contain PII related to students. The Children's Online Privacy Protection Act, COPPA, aims to protect children's privacy by requiring parental consent for the collection of PII from children under the age of 13. The Gramm-Leach-Bliley Act, GLBA, regulates the collection, disclosure, and protection of PII by financial institutions. Categories of PII. PII can be divided into two categories: non-sensitive PII and sensitive PII. Non-sensitive PII, information that can be transmitted in an unencrypted form without resulting in harm to the individual. This includes information that can be easily gathered from public records, phone books, and corporate directories. Sensitive PII, information that, when disclosed, could result in harm, embarrassment, inconvenience, or unfairness to an individual. This includes financial information, social security numbers, health information, and precise geographic location data. Challenges in protecting PII. The protection of PII faces numerous challenges, including the evolving nature of technology, the proliferation of data breaches, and the varying interpretations of what constitutes PII. Additionally, the global nature of the internet and digital transactions complicates the enforcement of US privacy laws, especially when data crosses international borders. Future directions. As technology advances and data collection practices become increasingly sophisticated, US privacy laws are under continuous scrutiny and adaptation. There is an ongoing debate about the adequacy of existing laws to protect PII and whether new legislation, such as a comprehensive federal privacy law, is needed to address the complexities of the digital age. Evolving definitions of PII. The definition of PII has evolved over time, reflecting changes in technology, social norms, and the increasing sophistication of methods used to identify individuals from seemingly anonymized data. This evolution challenges the traditional dichotomy between non-sensitive and sensitive PII, as advancements in data analytics have shown that even non-sensitive PII can be combined to create detailed profiles of individuals, potentially leading to re-identification and privacy breaches. Regulatory responses to evolving risks. As the risks associated with PII evolve, so too have regulatory responses. One notable example is the amendment of laws and regulations to cover broader categories of information. For instance, the definition of PII under HIPAA has expanded to include genetic information, reflecting advancements in medical technology and the increasing relevance of genetic data to individual privacy. Furthermore, regulatory bodies such as the Federal Trade Commission, FTC, have played a critical role in enforcing privacy laws and guiding the interpretation of PII. The FTC has taken action against companies for failing to protect PII adequately, using its authority to enforce principles of data security and privacy, even in the absence of specific legislation covering new types of data. State-level privacy laws. In addition to federal regulations, state-level laws in the United States have introduced their definitions and protections for PII. The California Consumer Privacy Act, CCPA, for example, grants California residents new rights regarding their personal information and imposes stricter obligations on entities that handle PII. the CCPA's definition of personal information is broader than in many federal statutes, reflecting a more expansive view of what constitutes PII. The patchwork of state-level privacy laws creates a complex regulatory landscape for companies that collect or process PII, necessitating compliance with multiple, sometimes conflicting regulations. This complexity underscores the calls for a comprehensive federal privacy law that would harmonize privacy protections across the US. The role of consumer consent. Consumer consent has become a central tenet of privacy law, reflecting the principle that individuals should have control over their PII. However, obtaining meaningful consent in the digital age is increasingly challenging. Privacy notices and consent forms are often lengthy, complex, and not user-friendly, making it difficult for consumers to make informed choices about their data. Regulatory efforts have sought to address these challenges by requiring clearer, more concise, and accessible privacy notices, and by giving consumers more straightforward mechanisms to consent to or refuse the processing of their PII. The GDPR, for example, sets a high standard for consent, requiring it to be freely given, specific, informed, and unambiguous. Data breaches and legal implications. Data breaches have become a significant concern for privacy law, as they often involve the unauthorized access or disclosure of PII. The legal implications of data breaches include not only regulatory investigations and penalties, but also the potential for civil litigation by affected individuals. Laws such as the California Consumer Privacy Act, CCPA, have introduced specific provisions related to data breaches, including the right for consumers to sue companies for certain unauthorized disclosures of PII. These legal frameworks aim to incentivize better data security practices and provide recourse for individuals whose privacy has been compromised. Privacy advocacy and litigation. Privacy advocacy groups play a crucial role in shaping privacy law and policy, often pushing for stronger protections for PII and raising awareness about privacy issues. Litigation brought by these groups, as well as by individual plaintiffs, has led to significant legal decisions that have clarified the scope of privacy rights and obligations. Recent privacy litigation has addressed issues such as the adequacy of consent mechanisms, the scope of data collection and retention practices, and the rights of individuals to access, correct, or delete their PII. These cases contribute to the evolving legal landscape of privacy law, influencing both legislative developments and corporate practices. Conclusion: the protection of personally identifiable information, PII, within US privacy law is a dynamic and complex field, reflecting the intersection of technology, law, and societal values. As the digital landscape continues to evolve, so too will the definitions, protections, and challenges surrounding PII. Understanding the current state of privacy law, the impact of emerging technologies, and the importance of consumer consent and data security is crucial for navigating this evolving legal terrain. The ongoing development of privacy practices and regulations will be key to safeguarding individual privacy rights in the digital age.